Good afternoon, and thank you so much for joining us for another Colonial Williamsburg live video. My name is Davia Brown, and today we're going to be talking about checks and balances, and that's as a part of our government and as a topic that's still very relevant today. We have with us the father of the Constitution, Secretary of State under Thomas Jefferson and fourth President of the United States of America, Mr. James Madison, and Chief Justice for the Supreme Court, Mr. John Marshall. We invite you to post your comments and questions for us to answer in this live video today. And we have also invited a vast number of members of Congress from the courts and from the state legislature to send in questions for us to answer today. Our first question is coming from the Honorable John Kohler.
Hello, I'm John Kohler, a citizen lawyer, and for the last 28 years it has been my privilege to serve as a law clerk in the appellate courts of the Commonwealth of Virginia. In this role, I've had a backstage view of the workings of government, and I've developed a great appreciation for the delicate role that the judiciary has in preserving the balance of power within our democracy. In Federalist 78, Alexander Hamilton said of the judicial branch that it may truly be said to have neither force nor will, but merely judgment. From this, Hamilton concluded that the judiciary is beyond comparison the weakest of the three departments of power. The role of the judiciary in the early republic was the least certain of the three branches. It might truly be said that the purpose was not defined until 1803, when a man named William Marbury had his day before the Supreme Court. Marbury was seeking a writ to direct Secretary of State James Madison to deliver to Marbury a commission as a Justice of the Peace, an appointment made on the last day of the John Adams administration 2 years before, in 1801, but which had not been delivered before Thomas Jefferson took office and directed Madison to withhold the appointment from Marbury. The decision which resulted, Marbury v. Madison, was written by Chief Justice John Marshall. In Marbury, Chief Justice Marshall performed a conjuring trick, whereby he appeared to give Jefferson and Madison a victory, while still finding that Madison had been wrong not to deliver the commission to Marbury. He did this by holding that while Madison ought to have delivered the commission, the law which gave the Supreme Court the power to enforce the delivery of the commission went beyond the authority entrusted to the court by the Constitution. Marshall declared that it is emphatically the province and duty of the judicial department to say what the law is. And this necessarily included the authority to declare acts of Congress, and presumably of the executive as well, to be unconstitutional. This doctrine, which became known as judicial review, is the true power of the judiciary within the delicate balance between the three branches of our government. So long as the courts exercise that power conservatively and without bias, the power of their judgment remains one of principal authority. So long as the executive and legislative branches accept that authority, the republic will remain strong. I think I would ask Chief Justice Marshall if he knew he was performing a conjuring trick with Marbury. Legal scholars, with the benefit of hindsight, have always assumed that Marshall took a very calculated approach to giving Jefferson and Madison a hollow victory. I have great respect for all the founders, but I've always wondered if Marshall wasn't being something of a rogue, albeit one of noble intentions, when he crafted his Marbury opinion. I would be more than a little disappointed to find out that he hadn't planned Marbury as the masterstroke it has subsequently been considered to be.
Well, thank you, Mr. Kohler, though I fear you may be sharing company with friends of Mr. Madison and Mr. Jefferson to have referred to the ruling of that case as a conjuring trick. The court certainly did not create the principle of judicial review out of whole cloth. 100 years earlier, when John Locke wrote of the three heads of government, he referred to the executive, the legislative, and then the federative. He did not even count the judicial as a separate branch or head of government because justices under the English Constitution were always beholden to the crown. When we created our new federal Constitution, though, well, perhaps I should say when Mr. Madison created it, we realized the necessity of having a written constitution that would require an arbiter, someone that would have the purview to decide what is or is not the law, someone to decide exactly how the Constitution would be interpreted in those necessary instances. So that is why we had recognized the necessity of judicial review, it having already been discussed in the Constitutional Convention, in the ratification conventions in the various states, and even when Publius wrote of it in the Federalist paper, number 78.
And indeed, while I will not speak to the implications of the Justice's decision, over the course of the administration of President Jefferson, I will speak in regards to the discussion which took place regarding the drafting of the federal Constitution. Now, I will say under the Virginia Plan, as it was introduced, the various articles crafted that would become our federal Constitution, initially it was debated as to whether the Supreme Court of the United States should, as a revisionary council, revise the laws in tandem with the president before a bill was signed into law. Thankfully, by the intercession of men like George Mason, men like myself, as well as the great many other gentlemen who assisted in the drafting of that Constitution, some 55 in number. Let it be said always that the government is the work of many heads and many hands. Inevitably, it was decided that the Supreme Court of the United States would be the highest court of appeals in the land. Not the ones who decide what the law is, no, rather instead the expositor or explainer of the laws, and not the trumpeter of party decisions.
Very well said, Mr. Marshall and Mr. Madison. Our next video question is coming to us from the Honorable Schuyler Van Valkenburg.
Hello, my name is Schuyler Van Valkenburg, and I'm a delegate for Henrico County in the Virginia House of Delegates and a civics teacher in Henrico County Public Schools. And Williamsburg asked me to talk about the importance of separation of powers and checks and balances. And I would say that the most important aspect of checks and balances and of separating power is that the goal is to ultimately make sure that people remain sovereign, that they maintain their power and their liberty, and the government cannot get it. And I think that Alexander Hamilton expressed this the most eloquently in Federalist 78, where he was defending judicial review, the ability of courts to strike down laws. And he said that this was needed, this was necessary, because otherwise it would affirm that the representatives of the people are superior to the people themselves. But the people are sovereign, and they're sovereign through the Constitution, and hence that check was vital to making sure people maintain power. And the brilliance of this system is that it sets up sovereignty with the first three words, we the people. The original Constitution ends in Article 7 with popular ratification, and in between is a whole layering of procedures and rules and actions where the different branches and levels of government can check each other, all bound around the notion that James Madison mentioned in Federalist 51 of ambition counteracting ambition. And they all knew that people are fallible, that institutions are fallible, that we make mistakes. And so they provided a whole series of steps to ensure that even if one branch fell down on the job, we would still have the appropriate separations and checks in place to make sure that we worked within the constitutional system. And so my question, because there's questions for James Madison and John Marshall at the end of this, is the founders didn't expect political parties, but very quickly parties popped up. Our system has adapted and done well, and I remain an optimist. But Justice Jackson, in a famous court case about executive power, said, the tool goes to those who can use it. And we've seen Congress not use its tools over the last couple of decades, and as a result, we've seen the rise of executive and judicial power. Are you afraid that Congress is no longer doing the job it's constitutionally supposed to do? That's my question for Madison and my question for Marshall. But I remain an optimist about the system that Madison and Hamilton and others laid out at the beginning, and that ambition will continue to counteract ambition. Thank you for listening.
job that it is constitutionally supposed to fulfill?
Well, I thank you for the question, Ms. Brown. It is a fitful thing to fear of. Of course, we can trust that enlightened statesmen will not always be at the helm. Equally, history has shown that those with ambition seek their appointments for three reasons. That ambition, a desire for the public good, and their own self-interest. That desire for the public good often being the minority of those various qualities. Now, we witnessed in our ancient regime how the various political party establishments of Whig and Tory favored the spirit of party over the spirit of unity that ought belong to every British subject. It was hotly desired that it be the equality of the American people to rise above that spirit of party. And yet America is a continent diverse in its quality. Having some now 16 states stretched from the original 13, we see faction pervading throughout this continent. Indeed, I should say there is no greater danger to a political society than that of faction. And unfortunately, there is no cure that is worse than the disease. For so as we are free to find our own mind and opinion, so too are we free to collect with those of like opinion. Now, from that, I have written regarding distinctions of natural faction. Those who follow one religion over another, the mercantile class, the farmers, the various distinctions and factions which make America so diverse. The great danger in these free societies is when a majority of those factions come together to punish the rights of a minority. Now, this is natural faction. Where then do we move to the notion of artificial faction, as we find it in the course of political party? What can be the benefit of such artificial institutions, whereby Americans define themselves not as members of one family, but instead as members of a party? It falls thusly, I think, to craft one party to be a check to another, so that ambition may counteract ambition, and that a whole majority of a government invested with that power cannot overleap the great barrier which are the rights of the American people. Now, with this comes an equal danger, that the American people do not find themselves so divided by that title of party, but rather as members of the same family. Let those of government be divided, to ensure a people may always conquer them, rather than a spirit of government be unified by a division of the people.
I recall in President Washington's statement prior to leaving office as the executive, he cautioned American to avoid political faction, to avoid party, that often they serve themselves rather than the interests of the people. And if there should come a point when the Congress ought to distance itself from its constitutional responsibilities as though that branch of government most directly aligned with the people, and most responsive to the interests of the people, in lieu of the executive or even the judicative branch, as counterintuitive as it might seem, I would caution against allowing the judiciary to assume so much more responsibility in that balance of powers between the different branches of the federal government. The judiciary being so far removed from the will of the people. It is our role to attend to those matters that are brought to the court through just and proper means, not to play a more active role in the nation's government.
Thank you both for those wonderful comments, Mr. Madison and Mr. Marshall. And in a vast country such as ours that is so filled with diversity, which is wonderful and something to be celebrated, that does seem to be a challenge of trying to maintain a sense of unity, and one that I hope that we continue to try to do. We actually have our first question from the audience. Madeline, age 9, asks, I know that all the branches are supposed to be balanced, but is there a branch that tends to like to have more power, and what would happen if that happened?
Madeline, a very good question, and I thank you for it. This has been debated since, well, before the Constitution was even ratified, before it was approved. In Philadelphia in 1787, when we were drafting that document that would become our Constitution, gentlemen had different ideas as to which branch of government should hold the greatest degree of power. And if they did, what would stop that branch of government from growing oppressive? Now, it might be obvious to seem that there was great fear in the executive branch, Article 2 of our Constitution, becoming the most monarchical, the most like a king. And yet the greater fear for gentlemen like myself was, of course, the legislative branch becoming the most oppressive, that all branches would be beholden to them for their favors, their privileges, their positions. Now, this is why, Madeline, we have the system of checks and balances that we hold, whereby the House of Representatives is elected by the people, they being the ones directly beholden to them, prone to debate, prone to party. And why equally we have the Senate. The Senate, which holds a 6-year term, is the more deliberate branch and thus is appointed by the state legislatures. And it's why equally we find the distance from the people in the Supreme Court of the United States, as my worthy colleague Justice Marshall was saying. An outstanding question. And moreover, we find within our Constitution not only the separation of powers, but also the separation of functions, each branch of government having a vested interest in the success of the other. After all, a justice will not be appointed without the ratification of the Senate, and just as such, a president will not find any appointment without the assistance and success of the Senate. They find themselves entirely interrelated, and for that reason, success, no matter how difficult, becomes the shared success of all.
Returning to that supreme law of the Constitution, one might infer simply by the length of the third article that the judiciary may be the least powerful of the branches. Indeed, it does not control the power of the purse, as does Congress, nor the sword, as the executive branch. Its authority comes from the recognition by the other branches and that respect of the Constitution, that it is only through an adherence to that principle that the separation of powers provides for a stable government. So even though it may appear that the judiciary does not hold a great amount of direct power, it is still a very vital component to our federal government.
Very well said. Melissa and Chad both wanted to mention that it seems many are oblivious to the checks and balances that are put in place and the tremendous insight that was applied in framing this nation. Would either of you like to comment on ways that that could be addressed?
A very good question. I think I should say first and foremost that no free government can long endure without a people who are enlightened. It is devoutly to be wished that the public opinion of the United States should be enlightened, familiar with the various charters that they are entrusted to defend. Knowledge will forever, I think, govern ignorance. And if a people wish to govern themselves, they must arm themselves with that power.
Before we declared independence, in Virginia, the only individuals who were elected to public office were the burgesses, the 2 burgesses from each county in Virginia. Otherwise, any other person who held political office in this colony held it by the favor of the crown. They knew someone who knew someone who knew the king, and they were appointed to their office, in some cases for life. Now that we have declared our independence, we have secured our new government, it is necessary that the people take a more active role in the function of their government. There are so many offices now that are elected rather than being appointed or selected from some cabal or secret group, that the American people no longer enjoy the luxury of lethargy in the public sphere.
I 100% agree with the fact that the people need to be involved in their government. Well said, Mr. Marshall. Ken would like to know about a good example of the checks and balances performing correctly throughout American history.
Well, you see them reflected throughout the Constitution in many ways. Oftentimes you might think of the court overturning a piece of legislation, as we did with the Judiciary Act of 1789, declaring it void as it conflicted with the Constitution. But there are a number of balances and checks, as Mr. Madison mentioned earlier. Any appointments that the executive wishes to make to his cabinet or other posts must first be received by the Senate for advice and consent. You also see instances where the executive may veto legislation from from Congress, and then the Congress might override that veto. So there are a great number of instances where you see checks and balances at play in our Constitution. Another one that is often overlooked is the separation of our federal powers between the national government and our state governments. Each individual state might serve as an opportunity to practice new theories, new policies might be attempted in scale before applied writ large on the whole nation.
I should agree in such form. The unique nature of our federal system of government is that it is supreme, but it is still limited in its power. Limited because each various state might keep in accordance the various powers not directly provisioned to the federal Constitution. And yet I should say the greatest example by which our system might endure is the peaceful transition of power, whereby we might commit a new revolution every 2 years, 4 years, and 6 years, without the sword being drawn from the scabbard, but instead with the power of the pen. We have witnessed this over the course of the last 3 presidential administrations. I have no doubt we will continue to do so ad infinitum, so long as this system may preserve the blessings of liberty for our posterity.
Hear, hear.
I'm sure there are many who would prefer to see revolutions with the pen rather than the sword. Our next question is coming from Michelle from Arkansas. She would like to know from Mr. Marshall and Mr. Madison if you could both talk about the famous case Marbury, which she says sounds like Marbury, versus Madison.
Mr. Kohler did an admirable job of explaining some of the particulars of the case earlier. It had to do with after the election of 1800, President Adams was roundly defeated. And then you see the appointment of a great number of justices by his administration to vacancies that had been created by the legislative passing the Judiciary Act of 1801. This is something that Mr. Jefferson and his administration seemed to take umbrage against. One of the justices who received an appointment to the District of Columbia was a man named William Marbury. He and 3 other gentlemen did not receive their commissions, though they had been signed and sealed, and I would have argued that that meant that they go into effect. But because they had not been delivered to them, they were never able to claim their office as a justice of the peace in the District of Columbia. So Mr. Marbury requested that the court, in accordance with the Judiciary Act of 1789, produce a document called a Writ of Mandamus. This is essentially an order from the court instructing some individual in the government to perform an act. Mr. Marbury was requesting the court to order Mr. Madison, as the Secretary of State, to produce his commission. Mr. Madison and Mr. Jefferson, for reasons of their own understanding, refused to follow through with this desire. But as I had mentioned earlier, the court not having any direct power of its own. If the court were to have found in favor of Mr. Marbury directly and to have ordered Mr. Madison to produce that commission, what would have been our recourse if Mr. Madison had refused to follow that order of the court? I'm sure Mr. Madison would not have done so. He would not have wished to imperil the good standing and the faith that the American people have in our Constitution. But the bench did not wish to hazard the possibility. So we found in one voice, una voce, a unanimous decision of the court, that though Mr. Marbury was entitled to his commission, the Judiciary Act of 1789 was in conflict with the Constitution, and as such, it must be void. It was struck as a law, and since it was not a valid law, he did not have the right to bring that case directly to the Supreme Court for his relief.
Indeed. You will imagine the great conundrum when I arrived at my desk, a freshly minted and appointed Secretary of State, to find such various appointments already at my desk, appointments of a previous administration. Now from that, as well the worthy Mr. Marshall set forth, I am one who binds himself adherently to the rules, to balance the great dilemma that exists. What was that under the rules, it was not my responsibility to deliver those various appointments. The gentleman whose responsibility it was to deliver those appointments, out of honor, I will not name.
Perhaps the gentleman in question rightly recognized that those commissions, having been signed and sealed with the seal of the United States, went into effect at that moment, and they did not necessarily require delivery.
Perhaps the gentleman in question, who out of honor I will not name, wished to rather find some insult and injury he could pay to his cousin, the recent presidential appointee. I'm speaking hypothetically. Again, I will not name the gentleman out of honor and dignity. But upon that, the condition of Chief Justice Marshall's action set forth a dangerous precedent whereby from the bench, these various justices can interpret an American common law, the various conditions which brought us to the condition with Great Britain, whereby laws once more became secundum subjectum materiam, all through the power of the Supreme Court of the United States. Indeed, myself and President Jefferson knew precisely what Chief Justice Marshall was doing when he put forward that opinion of the court, solidifying forever that the opinion of judges should be equal, nay, tantamount superior to that of the supreme law. And yet it furthers that selfsame notion of a government framed around balance. It was clever, I will admit, frustrating, but clever.
And yet perhaps favorable to the pell-mell that would have resulted if each individual branch of our government were left to its own devices to interpret how it might best represent its sphere of influence and exercise its own responsibilities without any arbiter to decide what is or is not the law.
Things got a little intense there. So let's move on to a couple of questions about checks and balances, and let's keep ourselves in check and balance, please. Aaron would like to know, if man made the system of checks and balances, can man unmake them or alter them? And Steve would like to know, what should a people do if the checks and balances begin to break down?
Both very unique questions. Now, a system of government begins to die almost as soon as it is constituted. It begins to die with the deterioration of its principles. One of the founding notions upon our system of government is that when any government becomes obstructive to its ends, in this example of life, liberty, the preservation of property and pursuit of happiness, it is the right of the people to alter or abolish that system of government. Now, America has set the example, and France has followed, of rearing a system of government based upon logic, reason, and how man might govern themselves ad infinitum, regardless of the peculiarity of time. The unique quality of our Constitution is that it finds itself entirely unfinished, and indeed shall never be finished until this experiment should conclude or the race of man find their end. Upon that, the process of amendment can ensure our system of government may continue to be balanced. And yet, should the alternative of these various things fall, should our system of government grow an impostor, whereby those various principles find themselves betrayed and the power unbalanced, well, it should be the right and responsibility of an enlightened citizenry to carefully ensure a balance of power for future generations.
You might say we've already experienced a want of balanced government under our organization in the Articles of Confederation. The principal powers being vested almost entirely and solely in a legislature, without a functional executive head, without a Supreme Court, rather only the state courts, which would bicker with one another. There was the infighting that comes with 13 separate heads all pulling and tugging at one another. You saw instances of great strife and conflict between the different states, border disputes erupting, questions of how one might proceed to enter into treaties or negotiations with foreign powers. And it was such an ineffectual system of government. It might have been one of the greatest promoters of the adoption of the new federal constitution.
Great response. Jarrett from Hawaii would like to know, what is the other branch's check on the executive branch for being the commander-in-chief of the military?
A very valid question. The check upon the executive. After all, the ties of the army remain firmly in his hands. Now, from that, the responsibility of the executive to sit in such powers as to make war existed once more from the necessity of the Articles of Confederation. We had no means whereby a common defense might lie, and moreover, we witnessed in the time that President Washington served as general that the Congress of the United States did everything they could to keep him from the necessary and adequate power requisite to win the war. And so from that, the powers of the military needed rest into the firm hands of an executive. The President, as Commander-in-Chief of the Armed Forces, sits in a way in which he can act with immediacy, secrecy, if necessary. But this brokers the question, what is to stop this President from one day becoming a Caesar, a Hannibal, a Philip of Macedon, and this fair experiment of republican principles being undone? Upon that, we find the check for that happily in Article 1 of our Constitution. It is, of course, the President's prerogative to make war, and yet it says explicitly in Article 1 of the Constitution that it is the power of Congress to declare it. Now, in that vein, we find a check, the one upon the other. Congress once more holding the power of the purse, and from that, if no coin sits ready at hand, a few swords can be purchased.
Truly. It's a frustrating situation one might find oneself. We wish to have that most terrible and awful power, the power to make war, be one that is not entered into lightly, which is why it is vested in the care and the protection of that branch which is most directly accountable to the people, the Congress. But of course it is ineffectual and inefficient to rely on a committee to manage the affairs of war, which is why that direct responsibility does fall more appropriately in the executive branch. Someone posed a rather curious question. They said, Congress may declare war, but who might declare peace? And I confessed I did not have a response close at hand for that curiosity.
That is a very good follow-up question to this question, Mr. Marshall, and definitely a good example of how we do need to rely on the three branches working together and keeping each other in check. We have a question from Robert. He would like to know, for both of you gentlemen, could you briefly discuss your philosophical and or political influences, perhaps Mr. Jefferson or Mr. Wythe?
A very good question. Now, I will say, of all the gentlemen I have had the privilege of working with over the course of a political career, which has spanned the past 30 years, there are few whom I'm as close with as one Thomas Jefferson. It has been said no two brothers are as close as he and I. And yet our relationship is not one of mentor and mentee, but rather of a dreamer and engineer. It has been often said of Thomas Jefferson that he legislates for the world he wishes to see. I legislate, or at least I endeavor to, for the world in which I live in. In that way, we have framed a partnership, he and I, one that has allowed the expansion of the American territory, as well as various things that have been beneficial to this idea of America. Now, as for my teachers growing up, I benefited greatly from the wisdom of Mr. Wythe, but I did not study law under him. Rather, instead, I studied under the old doctor, John Witherspoon, president of the College of New Jersey, signer of the Declaration of Independence. And yet my greatest teachers remain those that I find in books of self-study. Let it be remembered that our Constitution is the work of dedicated research, of hundreds of volumes of books of human history, of Herodotus, of Thucydides, of Fortunato Felice, of Diderot, of Montesquieu, and indeed of John Locke. Careful deliberation was taken by these various individuals who studied government so that we might perfect upon it. Is that not a perfect lesson for this system that we are set forward to perfect? Never to make a perfect system, but to leave account of our victories and, well, I will say equally, of our tragedies and pitfalls, so that future generations may pick up that same quill and leave a lasting legacy for their posterity.
One of the great teachers I find is experience. And to learn from the experience of one's life and our forebears. I am often reminded of that terrible winter at Valley Forge. When we went into winter quarters there, the Army was demoralized. General Washington would complain to Congress that he did not have enough shoes, so that the men on guard had to wrap their feet in rags. Men went hungry for want of food. And during that terrible winter, I served as a judge advocate in the Army, and it was my responsibility to prosecute soldiers of these United States for crimes committed, such as when they would steal food for themselves or their colleagues too sick to leave their quarters. So I've experienced firsthand the dangers and the pitfalls of a weak central government, one that was wholly ineffectual at providing for the basic necessities to keep an army in the field. Conducting negotiations with foreign powers was hampered, and as I alluded to earlier, the internal affairs of one state relating to another were also frequently in conflict. This is one of the instances in my life that has motivated me in ensuring that we have a strong authority, but one that is still constrained so that it may not become tyrannical or despotic, but has the ability to exercise the responsibilities needed to provide for the happiness, the well-being, and the success and the prosperity of the people.
Those are both wonderful responses, gentlemen, and I definitely do believe that experience and history and learning from the successes and the failures of people who've come before us are one of our greatest tools and teachers for how to continue with what we have currently and to improve upon it and attempt to perfect it. We are running out of time, so
Before we go, might we hear Mr. Allen's question?
Of course, yes. We actually do have a question from the Honorable George Allen.
Hello, I'm George Allen, former member of the House of Delegates, the U.S. Senate, and Governor of Virginia, and I'm pleased to be here to ask questions of James Madison, the author of the genius and enduring value and importance of our Constitution, as well as Chief Justice John Marshall, who is the exemplar for the judicial branch of our checks and balances in our country. I have several questions I'd like to ask both gentlemen that deal with what we've gone through with the reaction and decrees related to the COVID-19 pandemic. Number one, we've seen a lot of governors shutting down and making decrees, making all sorts of orders. And I would like to ask James Madison, as sort of checks and balance, do you think that state legislators ought to review and possibly revise the powers granted to governors in the midst of this pandemic? Should they have periods of time, for example, where the emergency decree would take place? What sort of check or balance should there be on governors when they're making such decrees? And finally, the question to the Chief Justice, Justice Marshall, for an understanding of what he thinks Congress might do in a matter of liability. So many businesses by government decree have been shut down. Do you think it would be appropriate in the midst of this as we reopen from this national coronavirus recovery situation, do you think that it would be appropriate for Congress to pass a law that gives liability protection to businesses who make a good faith effort to comply with CDC and other public health safety guidelines in their operations so they don't get hit with a lot of lawsuits as they try to reopen, create jobs, and provide the goods and services that are so important for our society?
Thank you so much for the question, Mr. Allen. We are facing some rather difficult times in our country, and it does definitely put on people's minds the nature of executive authority. And Mr. Madison, would you please answer that question on the nature of executive authority?
I will, Ms. Brown. This is a question that was asked before the year of our revolution in 1776. When our last royal governor of Virginia, Lord Dunmore, over-exercised his executive prerogative, the subjects of His Majesty the King here in Virginia defied his power just as they detested his villainy. So much so that when the time came to write the Constitution of 1776, one of my first political actions, the collaboration therein, indeed, the majority of executive power was stripped away. So afraid were we of an executive overreaching for his power that our first elected governor, Patrick Henry, found his job entirely difficult. The management and, in many instances, forced mismanagement of his administration. Our second elected governor, Thomas Jefferson, found the same, so much so that already by 1779 we were discussing the possibility of a new constitution for Virginia. Thomas Nelson had emergency powers warranted and given to him over the course of time at Yorktown, and I will confess, over the course of Virginia's history, we have continued to put forward new constitutions and amend the one we have to determine the relationship between executive and legislative. It is as old to this democratic-republican experiment of government as, well, this democratic-republican experiment of government, which shows the great virtue in the American ability to consistently experiment. And indeed, Ms. Brown, that is what America is, an experiment, whereby we seek not perfection, but to be a little better than the previous generation.
Perfectly said, Mr. Madison. And for Mr. Marshall, could you address the question Mr. Allen had about does Congress have the right to legislate protections for private industries?
I certainly would say that the Congress does have the ability to create such legislation that might regulate industry or shield it from frivolous litigation. I would urge caution, though, in the sense that Congress not use the authority to grant particular favor to one industry or another that might be seen to grant an undue benefit. In a system of economy such as ours, where each one ought to have the equal opportunity to succeed or fail on their own merits, it is not the place of the government to decide how best to regulate that market.
Thank you so much, Mr. Marshall, and thank you, Mr. Madison, as well. We have run out of time, but we do want to take this moment to thank you all so much for your questions and comments. They were very insightful. We'd also like to thank our Honorable Mr. John Kohler, Mr. Schuyler Van Valkenburg, and Mr. George Allen for sending in their questions. Their comments and opinions are their own, and they do not necessarily reflect those of the Colonial Williamsburg Foundation. One final thought is that we are still dealing with a lot of challenges as our forefathers have, and we will learn from their mistakes as we learn from their successes, and we the people has expanded to include more of the diversity that is a wonderful gift of this country. So please do continue to learn from your history and also take an active role and interest in your government and how it functions, because we are the sovereign ones. Thank you.